So thanks very much to Ono Academic College for sponsoring this joint meeting. At the time that I received the invitation to participate in the conference, we had no inkling of the events that were soon to transform the political landscape of the Middle East. And when I accepted the invitation, I assumed that my presentation would address the legitimacy of international military interventions, focusing on the connection between decision-making at the national and the international levels. And so my plan was to present here an aspect of the research that I've been pursuing for some time, which focuses on how 20 well-established constitutional democracies have taken their decisions within their own constitutional systems to participate or not to participate in the international military coalitions, specifically in Iraq in 1991 or 2003, and in Afghanistan beginning in 2001. So this is the 100-page version of that work. Gabby Bloom has seen part of it in an earlier iteration. So at that time, I had no idea, and none of us had any way to predict that a new international military coalition would begin assembling in March of this year for an intervention in Libya approved by the UN Security Council in Resolution 1973 of March 17th of this year. These events are still unfolding. I cannot address them except in a very preliminary way, but I do want to make some tentative remarks about them. Now, first of all, let me explain my title, Democratic Legitimacy of Internationally Authorized Military Interventions. So, first, what category of military actions did I have in mind when I formulated the title, Democratic Legitimacy of Internationally Authorized Military Interventions? So, in the first instance, this category includes the military interventions that have been authorized by the UN Security Council, using that familiar phrase, all necessary means. That has become familiar to us over a long series of resolutions. They include Resolution 678, that authorized the use of force to remove Iraq from Kuwait after January 15, 1991. And it continues through Resolution 1973 that authorizes all necessary means to enforce a no-fly zone over Libya and to protect the civilian population of Libya. In the 2 decades between Resolution 678 and Resolution 1973, there have been a significant number of Security Council resolutions of this type. Some illustrations would include the authorization involving Somalia in 1992, former Yugoslavia for certain purposes in the 1990s, Haiti in 1994. A somewhat different formula was used, but nonetheless it still qualifies under this typology for the Security Council mandate for the International Security Assistance Force in Afghanistan. So when I'm speaking of 3 examples that are of primary interest for my remarks today, that is Iraq in 1991, Afghanistan in 2001, and Libya in 2011, which conveniently fall 1 decade apart, each of them, I underscore the fact that these 3 actions did receive formal approval from the UN Security Council for the particular purposes that are specified in the resolutions. Now, my project is not limited to military actions that have had the benefit of formal Security Council authorization. Several of the most significant ones for my research have gone forward without an explicit grant of authority from the Security Council. The most important, of course, was referred to this morning, the US-led military action in Iraq beginning in March of 2003. The United States there had attempted to justify the renewal of military force by virtue of a claim that the authority conferred by Resolution 678 of 1990 either had never lapsed or had been revived when the Security Council made a determination in November of 2002 in Resolution 1441 that Iraq was and had been for some time in material breach of Security Council Resolution 687 of April 3rd, 1991 that had set the terms of the ceasefire in that conflict. Now, we all know that those justifications were heavily criticized. I'm not going to revisit them here. I just want to flag this category or a subcategory and call these either the imperfect authorizations where a proponent of military action invokes the Security Council, either by way of saying that something that the Security Council did in the distant past is still operative, or is considering going to the Security Council for a new approval or a further approval, but has not succeeded in obtaining a clear authorization. So we can take the Kosovo intervention of 1999, which was also mentioned this morning, as another illustration, along with the Iraq intervention of March of 2003. Some might want to call them non-authorizations, some might want to call them imperfect authorizations, but this will be the category where the Security Council either has not expressed itself at all yet, but is being asked or could be asked to do so, or where it has expressed itself, but not with optimal clarity. Now, Al Gross had noted this morning that after the NATO intervention in Kosovo in 1999, the following year, an independent International Commission on Kosovo used to be called the Goldstone Commission, but for some reason that name seems to have fallen out of favor. It coined that famous phrase, illegal but legitimate, to refer to the operation in Kosovo, and as was pointed out this morning, that commission urged the formula of criteria and procedures that would ensure that future substantively legitimate uses of military force would not be tainted with criticisms of formal illegality by virtue of having failed to receive the formal approval of the UN Security Council. So, for my project, I am assuming that there is a category of substantively just military operations. I'm not going to try to defend what substantive justice is. I'm just going to say, let's assume there is such a category. Certain political leaders are prepared to recommend military action with respect to this substantively just category. Military leaders have plans that they predict will be successful, and so the question that I'm posing is, how are such operations to attain the kind of legitimacy that flows from democratic decision-making in the constitutional systems of the countries that might participate? I want to focus on democratic legitimacy at the national level, which is where the fundamental constitutional decisions have to be taken. Now, before I turn to what gives democratic legitimacy in constitutional systems, there is a threshold question involving the sequence in which national and international decisions are to be taken if they are to be legitimate on both levels. So let's put ourselves in this pre-decisional phase when all we have is an emerging proposal or plan, say a proposal or plan to intervene in Libya. Let's stipulate that it is for a substantively legitimate objective and is, meets the justice criteria. And we have to ask who is to decide whether to go forward with this plan, who is to decide on the international plane, and who is to decide within each of the countries that is to take a decision whether to contribute. If all that we have is that the proposal enjoys support from one or more national executive leaders in their capacity as civilian head of government, and typically also as commander-in-chief of national military forces, but the proposal has not yet been deliberated on or voted on by any national parliament or by the UN Security Council, who should decide first what would be the optimal sequencing of these deliberations and votes so that the resulting decisional output will enjoy the fullest measure of democratic legitimacy. So let's take as an illustrative contrast two streamlined chronologies of national and international decision-making. These are the two phases of the Iraq conflict. The first is 1990 and 1991. The second is 2002 and 2003. So just in very streamlined chronology, in August of 1990, Iraq attacked Kuwait. The UN Charter establishes the substantive legitimacy of an international military response. Indeed, there's a collective security obligation in the Charter, but which states will respond to that call? So President George Herbert Walker Bush assembled a multilateral military coalition. The galvanizing presence was, of course, the dispatch of U.S. troops in very large numbers to the Gulf. All of this occurring by the first President Bush taking these decisions under his commander-in-chief authorities to deploy or redeploy U.S. troops without involving them in hostilities at that time. Now, in November of 1990, President Bush appealed to the Security Council to endorse the looming military action, and the Council did adopt Resolution 678. I believe the date was November 29th, 1990, and this was the one that established the pause of goodwill until January 15th, 1991. If Iraq would get out of Kuwait before then, there would be no military action, but if it remained in Kuwait as of January 15th, 1991, the pause of goodwill would expire. Now, all this happened and the U.S. Congress had not been involved, so President Bush was making a rather huge wager that the U.S. Congress and the U.S. public would back him up in a circumstance where we had no defense treaty with Kuwait, and all that we had was just the 1945 collective security commitment, never before invoked in quite this way. So a few days before that pause of goodwill was to expire on January 15th, 1991, I think it happened on January 11th in the Senate and January 14th in the House, but I might have those dates transposed. The House and Senate took their votes. It was actually a very close vote in the Senate. A switch of a few votes either way could have doomed that particular resolution. Nonetheless, both houses of Congress did approve. We have the first authorization for use of military force in Iraq, and military action began that night of January 16th. And within days thereafter, we then saw a series of other democratic parliaments taking complementary action. So votes taken in London and in France and in Madrid and in Canberra and in a number of other democratic countries where those parliaments registered their support for the international military action and their parliamentary support for executive decisions to participate in this coalition. Okay, so I've put this in terms of a large wager that President Bush, the first President Bush, made. Now, the second President Bush, we have a different sequence. In October of 2002, President George W. Bush went first to the U.S. Congress, not resting on the position that the old authorization for use of military force would authorize a second war in Iraq, although those arguments were heard. But he got approval for a second authorization for use of military force in Iraq by actually rather larger margins that time than had been the case in January of 1991. So he was equipped with this authorization in advance. So this was like the Congress empowering him to negotiate with Saddam Hussein, to negotiate with the UN Security Council from the position of strength, knowing that the Congress would be backing him up. November of 2002 was the phase of intensive U.S. diplomacy at the UN Security Council. It produced Resolution 1441, which is what we can call this imperfect authorization. There was no clear language authorizing renewal of military force at that time, although the U.S. position was that no such further authorization was needed. Then between November of 2002 and March of 2003, we had the continuation of multi-leveled diplomacy to try to achieve policy objectives without the renewal of military force. Those objectives at the time were mainly articulated in terms of compliance with the provisions of the ceasefire resolution, Resolution 687, concerning weapons of mass destruction. By March of 2003, President Bush made the requisite determination that Congress had required him to make. There was a formula that had to be recited to the effect that multilateral diplomacy had been exhausted, and equipped with the authorization that had already been given him, he went ahead and initiated the introduction of U.S. armed forces into new hostilities without the benefit of a further Security Council resolution. Now, we had quite intense debates in the United States and Columbia Law School at that time. I'm sorry that Professor Fletcher isn't here because he raised those debates to a very high level of visibility and advocacy. There were a few, including Fletcher, who thought that the authorization for use of military force was itself unconstitutional as an abdication of Congress's constitutional duty to make its own determination that the war should be initiated on the state of facts that was prevailing at the time that hostilities were to be renewed. And I disagreed then and now with that view. My position as a matter of US constitutional law was that Congress can exercise its constitutionally required responsibility by means of an advance delegation of authority to the president. So now, what point am I trying to make by comparing these two chronologies, or these two sequences? And this is problematic, but I think from the point of view of democratic legitimacy in the United States, in the end, both of these military operations did enjoy the necessary congressional approval, which is required under Article 2 of the Constitution and under the War Powers Resolution of 1973. In the end, they both enjoyed this, but the first President Bush, even though he proceeded in a more procedurally regular manner on the international plane, he was on very shaky constitutional ground in taking steps that made the war highly likely and perhaps even inevitable without knowing whether Congress was going to give him the constitutionally required support. So the younger President Bush took a series of steps of doubtful substantive legitimacy and questionable legality. He took them without the benefit of a further Security Council resolution, but when he was asking the Security Council for what became Resolution 1441, at least he knew that the Congress had already indicated its approval in accordance with the framework legislation that Congress had enacted in the War Powers Resolution. So, okay, that's the U.S. story. Now, sort of starting within a few days after January 15th, 1991, I began formulating a research problem, which is, well, how does the rest of the world make these decisions? Or how do the other well-established constitutional democracies take their decisions whether to participate in external military commitments? So I formulated a research project which I didn't actually find it time to pursue at that moment, but beginning in the 1990s, I set a research agenda that focused on the 20 constitutional democracies with the longest and the most successful records of constitutional governance. That includes Israel, by the way. And these 20 countries almost... We didn't know. Well, because I had these longevity criteria, and so you're a very young country, but I started my my durational criteria basically beginning either from 1945 or from the acquisition of independence within a few years after 1945. Israel, however, did not participate in the same way that almost all the other 20 countries that I had put in my country set had done. It did not. It participated, let's say, passively. It did not send troops outside the national territory to participate in a war against Iraq in 1991 or 2003, and it has not sent troops to the NATO ISAF, even though more than 40 countries are participating in the International Security Assistance Force in Afghanistan, some but not all of those being NATO countries. So in the last 2 years, I zeroed in on an aspect of my long-running research project to try to figure out how those of those countries that did participate in either or both of the Iraq coalitions or in the Afghanistan coalition took their decisions to do so. And my 100-page paper, which fortunately I will be gavelled down before I can read, I will just summarize the key claims of it. There are really just 6 propositions. 5 minutes, 6 propositions, 5 minutes. Okay. First proposition, that parliaments and the people that they represent have been demanding a greater role in the decisions to make external military commitments. Second, that governments have been acceding to these demands, not only politically, but by accepting the need for improved constitutional arrangements to enhance parliamentary involvement. Third, that actual constitutional change is going on. So we've had a formal constitutional amendment in France. In 2008, Article 35 of the French Constitution was amended so that Parliament has a role that it never had before, namely that it is required to take a vote on an international military intervention that will be continued for longer than 4 months. Similarly, in the United Kingdom, where there has never been, we won't get into the question of what constitutes constitutional change in the United Kingdom, but there have been demands for a formalization of Parliament's decision-making role. Under Prime Minister Gordon Brown, following up on demands that came from the then opposition, led by David Cameron, there was a white paper put forward on specifying a more formal role for Parliament so that it would have a structured opportunity to deliberate and vote. Now, the fourth proposition is that parliaments and public opinion are increasingly concerned to connect the constitutional decisions on war powers with the international legal appraisal of a military commitment. So we see more and more demand in parliaments to hear, well, where's your legal brief? Where's the Attorney General's opinion? Where is the case that this war is going to be lawful in international law? Fifth is that courts are increasingly being asked to rule on the constitutionality of military engagements or their compatibility with international law or both. And in some cases, the courts have constrained the executive from supporting military actions that fall short of constitutional or international norms. And the sixth proposition is that all of the foregoing phenomena are noticeably affected by corresponding developments in other constitutional democracies. So now just the Libya postscript to this, with the rapidly unfolding events of the last 2 months in Libya, I'm putting it on my medium-term agenda to bring all this research up to date for the same 20 countries to figure out which one of those are participating and how they have taken their democratic decisions. It's not even actually that easy to figure out what the different NATO members of this coalition are exactly doing. Let's just say that some of these criteria of transparency may not be fully fulfilled. It's too soon to draw any definite conclusions. One of the reasons that it's too soon to draw definite conclusions is that in at least some constitutional systems, of which the example I've just given for France is an illustration, the time for Parliament to exercise its constitutionally required role would not have elapsed. Parliament there may have already taken a vote. That's not something I've been able to research. We can say, for example, that for countries that have clearly established constitutional requirements of parliamentary vote, it has been very difficult for them to proceed in any other way other than saying we won't vote for it and we won't even do it. So Germany, for example, has a constitutional requirement, as the Federal Constitutional Court determined in several important cases of the 1990s. The requirement is that in principle, in advance, the Bundestag must authorize the dispatch of German armed forces to an overseas military action, and that approval must be periodically renewed. So the Bundestag has given annual approvals to the German deployments to Afghanistan, but when the matter came up for vote at the Security Council on Resolution 1973, Germany was one of 5 countries that abstained. Now, it may well have abstained because of doubts about the wisdom of the action. Indeed, in the explanation that the German representative gave at the meeting where Resolution 1973 was approved, what was stressed was the risks, the dangers of military action. But one has to speculate that German constitutional requirements might have been in the background there. German naval forces in the Mediterranean are playing a behind-the-scenes role in support of NATO forces, but because of the constitutionally problematic nature of affirmative German participation, short of a formal resolution of approval from the Bundestag, this support role has to be very much in the background. Therefore, because the Bundestag has approved German participation in the NATO ISAF, there has been a certain shuffling around of personnel so that 300 German troops are going to Afghanistan, thereby freeing up a corresponding number from other NATO ISAF participants who are redeploying to the Libyan theater. So I guess the last word I'll say is that from the point of view of US constitutional requirements, the Obama administration did not request congressional approval and maintains that there is no constitutional or statutory requirement to do so. On April 1st of this year, the Office of Legal Counsel in the Department of Justice prepared or formalized a memorandum for the Attorney General that was released to the public in early April. It's 14 pages of dense and very unpersuasive legal argumentation contending that the President has constitutional authority to direct the use of force in Libya and that prior congressional approval was not constitutionally required to use military force in the limited operation under consideration. If the War Powers Resolution did begin to bite, if the clock under the War Powers Resolution began ticking when the bombs started dropping, which is kind of an intuitively plausible hypothesis, the 60-day timetable under the War Powers Resolution arrived on Friday of last week, and not surprisingly, the Obama administration went on a sort of media blitz or congressional relations persuasion operation, and a new letter was sent to House Speaker John Boehner and 3 other congressional leaders emphasizing the very limited nature of US participation, which is said to have been confined to 1, non-kinetic support to the NATO-led operation, including intelligence, logistical support, and search and rescue assistance, 2, aircraft that have assisted in the suppression and destruction of air defenses in support of the no-fly zone, and 3, precision strikes by unmanned aerial vehicles against a limited set of clearly defined targets. So, so, you know, there's a fascinating debate in the United States about what constitutes the initiation of hostilities or the introduction of US armed forces into hostilities and what happens if there is a diminution or an interruption in hostilities. But let's just say that we are in an imperfect situation, in my view, as far as compliance with US constitutional requirements. So just to conclude, for most constitutional democracies, legitimacy has to be secured at both the international and the domestic levels. For most constitutional democracies, this is going to mean a formal resolution of approval from the Security Council of the sort that we do have in Resolution 1973. And for most of them, it means some measure of national parliamentary participation. At a minimum, there should be an opportunity for an open deliberation over the merits of the proposed action, and in an increasing number of constitutional democracies, a requirement of a formal parliamentary vote is also being constitutionalized. So whether this is a normatively desirable trend and why it is happening is something I hope we can discuss in the question period.